Somebody would ask me, oh, why should I study company law and I want to be an accountant? The answer is very important. The answer is very simple. That you as an accountant, eventually, you will be transacting for a particular establishment. Whether you are transacting for Toyota Rwanda, you are transacting for the government of Rwanda, you are transacting for Minecofin, you will be transacting for a business establishment. Business transactions the whole world are undertaken through corporate entities. All serious businesses are through corporate entities. A corporate entity is simply a corporation or a company. And this will include the government itself. At some point, the government acts like a company because it is a company having companies inside. What do I mean? When you look at Minecofin, for example, and all those other ministries, those ministries legally, they are actually companies, but companies of the government companies. But of course, we shall not be talking about government and the government companies. We shall be talking about companies in general. So it is important that you as an aspiring accountant, you understand principles concerning formation of a company, administration and management of a company, and dissolution of a company. How do you form companies? What are the procedures? Where do we form this company? How do we manage companies? Who are the administrators of companies? And what are the procedures of managing the company? You talk about directors, you talk about managers, talk about supervisors. We need to understand this. Then there comes a time when a company must end its life for many reasons. Maybe the company is insolvent. The company has become broke. Maybe the company has ended its purpose, its objective. Maybe the company has been found to undertake illegal transactions. So we also need to understand dissolution of companies, the coming to an end of these companies. Okay? Now, the law that governs companies in Rwanda is the Companies Act of Rwanda. That is the Gazette Notice of 8th February 2021. Until very recently, the law which was governing companies in Rwanda was the Gazette Notice of 2018. But we are no longer using that Gazette Notice of 2018. We are using the Gazette Notice of 2021 as it is modified every other period of time. So we are relying on Gazette Notice of 2021. And the principles of law of Rwanda. It is not only the Companies Act that governs companies, also the general law of Rwanda also governs companies. So we're going to look at all this. We have 14 chapters which we are supposed to go through in preparation for the examination. 14 chapters. These 14 chapters, ladies and gentlemen, we will manage. Don't worry. We will manage them. We've managed them before. We are going to do it yet again. 14 chapters. All these chapters are very important. All these chapters are examined by ICPAR. Okay? Now, what are the study materials that we expect? We moved on to the next slide. Can you see the second slide, ladies and gentlemen?
Yes.
Okay. Now.
Yes, I will see.
Sawa. What are the study materials? Now, these study materials, all of them I am going to provide you with them. First and foremost, I will give you soft copies of these materials. And as we you will get both soft copy and hard copy. Immediately, today, you will be getting soft copy of this information, and thereafter hard copies will come as we proceed. Now, these study materials are our Bible. These study materials are our Bible. We cannot prepare ourselves for the ICPAR I-13 examination without this study material, and we cannot prepare ourselves for the ICPAR examination by looking outside this study material. If somebody brings other things which are not part of this study material, my friend, those things may not be relevant with the ICPAR examination. Number one, the Companies Act 2021. The Companies Act 2021, as I've just mentioned, is the basis, it is the foundation of this subject. And I will give you a copy of this document, a soft copy of the Companies Act 2021. I shall give you a copy of this document. 1 minute, I just show you a small clip of that. Can you see a change on your screen?
Yes.
This is a copy of the Companies Act 2021. And I will give you a soft copy of this. As you can see, it is the official Gazette number 4, which was given authority by His Excellency the President Mzee Kagame on 8th of February 2021. And there are always updates. There are always updates. And these updates, as they come, we shall be looking at them. If any update will come that is beyond the 8th of February 2021. Now, the document is a big document, but you don't have to worry. You don't have to worry because we will not look at the whole document. We do not want to become a notary. You don't want to become a lawyer. We shall pick the relevant parts of the document only. Example, relevant parts which will connect with our discussions in class. I have ensured that I have highlighted them. So it is going to be very simple for you to understand this document. Just want to show you an example of areas where we have an important thing. I can even start with just the beginning up there. Article 9, Article 6, telling us what is a company, etc. Look at that example. Article 34, dispensation to add the abbreviation limited. Now, we must add the word limited to the company. But then we are being told there are times when you are allowed not to add the word limited. So important areas I have highlighted. Abbreviation as to the name of limited company, etc. Those are the areas we are going to be looking at, not the whole document. So don't worry. Some of you will say, if we are going to read this document, we are going to finish 5 years. No. It is only the important areas. Validity of incorporation documents, such small things we pick out, connecting them with the examination questions.
Yeah.
Articles of association, we pick them slowly by slowly. So there are quite a number of highlighted things. Which, as we proceed, you will have this document, you will have your own copy, and I will also have my copy. Example, yes. So you see, types of companies. Okay, Article 11. According to the categories of companies set forth in this law, companies are grouped into the following types: a company limited by shares, a company limited by guarantee, a company limited by share and by guarantee. And then we have what? A protected cell company. And then we are given explanation there in the law, as the law says. We are not going to rely on stories we've been given by somebody. We will not rely on stories given by somebody. We'll rely on the law itself. Okay? So this is just an example of the areas we shall be looking at. Areas which are important are already highlighted in the document. Company's objectives. Every company is considered to be established for commercial purposes. Categories of companies. Categories of companies are private company and public company. Categories are private and public. But when you continue down there, types of companies, now there are 5. Types of companies you find we are being told limited by share, limited by guarantee, and limited like that. Okay, so this is what? This is the Companies Act, which will form part of the study material. It will be the main study material. Okay, then we go back. Apart from the Companies Act, I've changed the slide back again. Apart from the Companies Act, we're going to have the course lecturer's notes. My notes, the notes I have prepared. These notes, I have prepared them basing on the Companies Act 2021 and the law of Rwanda. So the notes are an explanation, a simpler explanation for the student to understand. Explanation of what? The Companies Act and the laws of Rwanda concerning companies. These notes, I will give you soft copy immediately today. Apart from that, you shall get a hard copy from the office. Okay? And let me give you a clip of the soft copy notes. These notes are updated. These are updated notes. I've changed back to a different clip. Now, the notes are in form of chapters, and there are the 14 chapters that I have mentioned. But I can tell you, I have reduced them. I have reduced them drastically so that it is simple for you to go through the notes and be ready for the examination. They are 91 pages. The notes are 91 pages. If you look at other notes, other texts from wherever else, I don't know where, you'll find a textbook of 300 pages, a textbook of 250 pages. When will you finish reading and understanding? That is a big problem for you. Especially some of you are family people, most of you are working. When will you have time to read these things? So this one, they are in simplified form, and 2, very brief. And they are revised. They have been revised and updated as at June 2021. In important areas of these notes, I ensure that I connect with the particular article. If there is an article, a particular section of the Companies Act, I connect them in the notes so that as you read the notes, you can know, this one is talking about a particular part of the law. Which part of the law? It is mentioned in there. That is what the notes are going to look like. Okay? Example, you can see this also here. If you can look at that, another example where we are saying NB, the Companies Act 2021 does not regard companies from East Africa community as foreign companies. They are treated as local. Okay? Now, when I tell you that, I should be able to prove, because I don't want to kubeshia. I don't want to give you a story which is not true. So how do I prove? I tell you, go and check Article 2 and Article 248. When you check Article 2 and Article 248 of the Companies Act, you find that is what the law says. So that is what we are doing with our notes, and it will be very simple for you to just go through these notes as we continue our discussions. Very serious areas are highlighted, and it is in form of chapter by chapter like that. Okay, those are the notes. You will get a soft copy. Another example there. When we look at this one, the New Companies Act. The New Companies Act provides that every company shall be regarded to have been incorporated for commercial purposes. Where do we get this story? Article 4. So nobody can come and say, no. This story is Kubesia. If he's saying it is Kubesia, we show the actual law. The law is telling us so. Unless you want to say the law is Kubesia, that is okay. Otherwise, we are just following the law. So that is how this situation will be. Those are the notes. And we shall be following the notes chapter by chapter, side by side, with another document. If we go back to our slide, course lecturer's notes, we've already mentioned that. The other important thing formation of a company, when we talk about the existence of a company, we must understand a very important case, Salomon versus Salomon and Company. Okay, now, in order for us to understand this case, Salomon versus Salomon and Company, and to see the connection of this case with the company law, we need to look at the facts of the case. So what I'm saying is the third study material is leading company law cases. And I will show you an example here. There are 17 important cases which a student who is studying company law must have an understanding. I believe you can see the screen now.
Yes. Yes, we are seeing.
Yes, the leading company law cases. The first case, the grandmother of company law is
Salomon versus
Salomon and Company.
Cases
yes. This is the case which tells us that yourself, myself, and Peter, if we have a small business and we transform this business into a company, that business becomes separate and distinct from ourselves who have formed it. So Salomon versus Salomon and Company talks about distinct legal personality. That the moment you form a company, you follow procedures of incorporation at RDB. You know where RDB is? Office of Registrar General. When you go to the Office of Registrar General at RDB and you change your small business into a company, yourself and the business are separate and distinct. You have different lives. If you have debts, those are your own debts. If you have property, that is your own property. Your debts and your property are different from the debts and the property of the company you have formed, even though the company is yours. Very important principle. So this is just the first case, and there are 17 of these cases. Salomon, In each one of the case, we show what the principle is, what the rule is. Solomon versus Solomon and Company, it is about distinct legal personality. And then we see the facts. The facts are very brief. And what the judgment was made, what the court said. Another important case is what? Makaura versus Northern Assurance. This one is about what principle? Capacity to contract. When you form a company, the company can enter contracts in its name. The company can borrow in its name. The company can sue. It can go to court in its name. Makaura. Another important case is Ashbury Courage and Iron versus Raishi. Now, this one is about ultra. My friends, we shall understand that there are quite a number of principles which have some nice words, like this one, ultra vires. These words are very simple. Don't worry, they are very simple. Ultra vires is a legal term which simply means beyond the powers. That if in our company there is a document called Memorandum of Association and there's another called Articles of Association. In Memorandum of Association, if we have said our objects, what we are supposed to do, is to make telephone, mobile phone, to make a mobile phone and sell. If that is what you have written in our memorandum, and then we start cooking chapati and mandazi and selling, my friend, what we have done is ultra vires. Because we have told the registrar our job is making mobile phone and selling, but now we are making chapati and mandazi. It is against the law. So Ashbury Courage and Iron, they show us an example of a case where the company decided to do things which were not in the memorandum. That is an example. We continue. There are 17 of these cases. We continue like that. Kellner versus Baxter. We continue. Trevor versus Whitworth. Sharp versus this
please, lecturer.
Case.
Please.
Yes. Yes.
Come again with ultravia. I don't really understand.
Okay. Now, for today, the objective is not for us to understand everything. For today, the objective is for us to a short preview of what we are going to come across. But I can explain it, no problem.
Yeah.
Ultra vires is a legal term which means beyond the powers or above authority.
Yes.
Now, when we are forming a company, there are two important documents. We have Articles of Association and we have Memorandum of Association. These two documents must be written and taken to the Office of Registrar General, ORG, where? At RDB. What we have written in the memorandum, our objectives are to repair laptops. Then, yes, my friend, we should only be repairing laptops. If after some time we start making beds and tables and cooking a mandazi, we can be taken to court. We will be asked, who told you to make beds and cook a mandazi? You told us you'll be repairing laptops. So what you have done is bias the memorandum. It is beyond the power that you've been given. And this case, Ashbury Courage and Iron, it shows us a situation where the management of a company decided to do something different from what the objects were. And the court told them, my friends, what you have done is beyond your powers. You are personally responsible. If you do something which is beyond your powers, the law says you are personally responsible. It is not the responsibility of the company. It is now your own responsibility. Let me give you an example. Let us talk of something different. A police officer. A police officer follows the procedures and the rules he has been given by by the government. Okay? Now, if the police officer decides to do things which are not in accordance with the law, my friend, the law will tell him, these things you have done are your own, and you are therefore personally responsible. The guy will be taken to court and he'll be taken to jail. So we must act within our authority. So there are 17 of these cases, and each case has a principle. Kellner is about pre-incorporation contracts. Hickman is about contractual effect of articles. Each principle I put in brackets. Trevor is about company to purchase its shares, etc., etc. This document, my friends, is another document I will give you as soft copy. There are 17 of them. Okay. Kingston Cotton Mills, obligation of an auditor. Leonard Carrying Company, organic theory. All this I shall give you as part of your study material, soft copy. Okay. Then we go back. Leading company law cases, we will also have ICPAR past paper examinations. You know, we can read all the law that concerns companies and we can become experts in the law concerning companies. But then there is another problem. This knowledge that we have concerning companies, is it relevant to the type of questions which ICPAR will ask us? We can be reading company law like we want to become lawyers. And then when we go to do the ICPAR examination, they ask company law knowing that they are asking accountants, not lawyers. So the degree of information that ICPAR expects in our answers in company law is different from what they will expect from a judge or from a lawyer. So it is important for us to have what? ICPAR past paper examinations. Now, this also, I shall provide to you past paper examinations of ICPAR. This is just a small glimpse. Can you see the screen? Yes.
Yes, we see it. We see.
So all these files here, these are past paper examinations. Starting from the first ICPAR company law examination, 2013 is supposed to be somewhere there. This one, December 2013, this was the first ICPAR examination. Continuing like that, up to the immediate, the one people did the other day, that one I'm going to add. Only that I have not found it on the website, but I will organize and will get it. But you can see, we already have April 2021, we have August 2021. So this one of December will not be a problem. We are going to get that one also. I will give you a whole file of all these past papers. Soft copy. I will give you soft copy of all these past papers. Apart from the soft copy of these past papers, in the book, the hard copy, not the soft copy, the hard copy book, the hard copy class notes, we also have those past papers. Whenever we shall be going through our notes, our discussions, looking at the Companies Act, etc., we shall be connecting with the past paper questions so that we understand what exactly the examiner is asking, what degree of explanation does he expect. The cases that I have shown you, something interesting is that the ICPAR examiner 95% of the questions are case study. If you have already looked at the I-13 company law paper, you can confirm I'm telling you the truth. 95%, in fact, more than 95%, it is case study. You get a long story there. Let me tell you the truth. Those stories you are going to see in the case study, in the past paper questions, they are not stories created by ICPAR. No. They are not created by ICPAR. You can even go and ask ICPAR if you have a relative there. Those stories are not created by ICPAR. Those stories are actually from the leading company law cases. ICPAR picks a particular principle, a particular rule. For example, this case of Solomon versus Solomon, that when people come together and they form a company, the company becomes different from the people who have formed it. They look at a case like Solomon versus Solomon, and then they give you a story, but they will not tell you Solomon versus Solomon. They will now tell you Uwase and Rukundo. They now give you the local names. They give you the local Rwanda names, the local African names. But the story, when you look at the story properly, it is these cases from where? From the celebrated company law courts. So, past paper examinations, we shall be using them basing on the notes and the Companies Act. And when we look at case study, the cases shall be very important.
Please, lecturer.
Yes, please.
Please.
Yes.
How can we find this leading company law case? It's a book.
Yes.
It's a book.
Okay. Can somebody help me to answer that question? Can somebody help me to answer him?
Will give us on soft copy.
Exactly. Yego, exactly. I have already said,
you.
Yes, you see this? Do you see what is on the screen now? The study material. This is study material I will give you. So
thank you so much.
Hey, Yego, these leading company law cases, I have shown you the document here, 17 of these cases. These are the ones I'm talking about. It is these ones. These are the ones I am talking about that I am going to give you. And the examiner picks one or several of these and gives you a story, and then you say, hey, now, this is a story about Rukundo, this story about Uwamaria. No. It is actually about Ashbury and Courage, or it is about this particular case. So this document, I will give you soft copy. You don't have to worry about that. Then we go back. The other information I need to bring to you is, and we shall be answering these questions, by the way, as we continue chapter by chapter. We shall be answering chapter 1, at least we answer like 2-3 questions, chapter 2, 2-3 questions, chapter 3, up to the 14th chapter. After that, we shall have revision. Again, now proper revision, where we shall be answering questions in full. Apart from the ICPAR past paper examination papers, we'll also have model questions. My own questions I will model just to prepare you. Now, these model questions will be a mixture of some of those which have already been asked in ICPAR exams, and then I mix them with some principles in law, just to confuse our mind, and see how we can reason. We're going to have those model questions. Okay?
Yeah.
Apart from that, class discussions. And I always insist, and I said that when we started the class, there is no calculation. There is no calculation in company law. In company law, we must ensure that we discuss, we must ensure that we argue. Arguments are important, okay? Positive arguments. Give me your facts, give me your points, and let me give you my facts, give you my points. Let us see which ones are making sense. That argument brings the best out of us. So class discussions will be part of our study material. And I am encouraging you, ensure that we discuss. There is a gentleman here who is asking many questions. I like such people. That gentleman, I want you to keep it up. Keep it up. What you are doing is very good. And there is a lady who is always answering also there. So when you do that, you sharpen your mind. And when you do that, you also help me to know which area should I emphasize. So I'm encouraging all of you. I can see we have about 26 people in class. I encourage you to ask questions. There is no question which is a foolish question. All questions are valid. Do not fear. God works in very interesting ways. Sometimes you may decide you do not want to ask a question, only for you to realize in the examination that what you are fearing to ask is the one which is being asked. So when you have the question, ask. If you don't want to ask the class directly, ask your friend. Your friend may have an answer, or your friend may have the courage to ask the class. So please, class discussions, very, very, very important. Okay. Then, last but not least, we shall have cuts and assignments. Cuts, continuous assessments. It is important, my friends, that we do these continuous assessments. We shall have cuts and assessments. We need to do these cuts and assessments so that we measure, we gauge ourselves. We gauge ourselves. Okay. The cuts, I'll give you a minimum of 3 cuts. Minimum 3 cuts. And then assignments, which will have as many assignments as possible. With assignments, I can even give you just 1 question. At the end of the lesson, I give you 1 question. And in the next session, I would like to have an answer. We do this, and for purposes of knowing the progress, we shall be recording marks. So management will require your marks. They want to know, are you taking things seriously? Very, very important. So basically, that is the important slide that I wanted to show you. For those who have just entered class, I said that is my name. If you can see there on the screen, that is my name. That is my email address, and that is my Rwanda number, 0784-650-083, Rwanda number. But then we also have WhatsApp. The number on WhatsApp, that is a Kenya number. But this other number, Rwanda. So if you want to make telephone, you can call me on Rwanda number. I can get responded to Wase. I don't know if Wase has entered class. Wase, have you entered class? Okay. Then, the other thing I said is that we are following the law of Rwanda, the Companies Act of Rwanda, 2021. And we have 14 chapters which we have to cover. It is important for us, even though you guys are accountants, it is important for you to understand company law, because business transactions are handled through corporate entities. Business transactions are handled through companies. Whether it is at government level or at a private level, it is through companies, corporate entities. Okay. Then I've said we have 14 chapters, which we are going to look at. We're going to have a brief. We are going to have a brief to look through the course content in a moment. The other thing I've said is study material. Our study material includes the Companies Act 2021, my notes updated 2021, past paper examination papers from 2013 to the immediate previous examination, model questions, class discussions, cuts and assignments. Now, all this information, I will give you soft copy.
Yes.
All this information, you're going to get soft copy. And in the course of time, you will get hard copy of the notes. You'll get hard copy of the notes. But before you get hard copy of the notes, you will have gotten soft copy of the notes. Okay? So, then, these 14 chapters, can we have a brief, just a brief understanding of what we are expected to encounter in the 14 chapters? Are there people who are still outside the class? Because I do not understand why some people are saying they cannot enter class. Okay, so chapter 1, out of the 14 chapters, chapter 1, nature and classification of companies. Now, tell me, in your own understanding, what do you think a company is? Anybody? Business organization made by one or more persons. Sawa. Can you add something else there?
With the intention to make a profit.
Okay, with intention to make profit. Something else?
Must be registered under the Companies Act.
Here you go. Sawa. So that information you guys have given is correct on condition that it must be registered under the Companies Act. If it is not registered under the Companies Act, my friend, it can be what? It can be a partnership. Yes? It can be any other thing. So as long as one or more people come together with the objective being business and they follow the procedures of registration under the Companies Act, then that is a company. So in chapter 1, nature and classification of companies, we shall be looking at this. Forms of business organizations. There are very many types of business organizations. Can somebody mention some of these types? Sole trader, partnership, cooperatives, sawa. So you find there are very many forms of business organizations. We have to look at them, but we shall not look at them in detail. They'll be very brief. There is an officer who is not hearing me. This is Nadia. Nadia, why are you not hearing me? Can the other people hear me?
Yes.
Nadia, I think the problem is on your side. Check your machine. Check your voice. muted or your voice is very low. Otherwise, other people are hearing. So we will briefly look at those other forms of business organizations, and thereafter, we shall then look at the company itself, the theory of corporate personality. This is where we shall look at the rule in Solomon versus Solomon. This is where we shall look at the rule in Solomon versus Solomon. And as we said, in simple terms, what happened with this story? Solomon was making shoes. He used to make shoes and sell them.
Yes.
Now, this Musaza then decided this idea of having a small business of making shoes and selling, I am not getting enough profit. What can I do so that I can get more profit? Then he looked around and he realized, there is something called a company. I should form a company. But when he looked at the procedures of forming a company, at that time, he realized that in order to form a public company, you need minimum 7 members. You need minimum 7 members. At that time, presently, my friend, when we look at the Companies Act, we are going to be told 1 or more can form a company. So when he realized you need a minimum of 7, he then looked around and he was the only person who had an income in his family. His wife and his children were not working. A total number, they were 7. Solomon, his wife, those are 2, and then there are 5 children. So Solomon decided that the law says each one of these members must contribute to the share capital of the company. Solomon had all the money. So he gave his wife a share, and each one of the children also a share. And the rest of the shares came from Solomon. So technically, these people became shareholders, even though the money came from Papa. And they registered the company and they started doing business. After some time, the business was not doing well. The business was insolvent. Insolvency means what? Broke, bankrupt. When it became bankrupt, the creditors went to demand for payment. And the payment was made by selling the assets of the company. All the assets of the company were sold, but unfortunately, they were not enough to clear the debt. Okay? Now, the assets are not enough to clear the debt. The creditor then said, now, we have sold everything of the company, assets enough to clear the debt, but Solomon is there, and we know Solomon has money. If we check with the bank, if we check at his house, he has a property. So, we want the court to order that the property of Solomon to be taken so that it clear the debt. The court said, no, you cannot do that. The moment Solomon formed the company, Solomon became separate from the company. The property of Solomon is Solomon's property. The property of the company is the company's property. Who is having the debt? The company is having the debt. So the company is the one to pay and not Solomon. And that was it. That is the simple case. The rule in Solomon by Solomon tells us what? That the moment a company is formed, it becomes distinct and separate from those who form it. So we shall be looking at this case and we shall understand the theory of corporate personality. And then we ask ourselves also, are there advantages of forming a company? Of course there are. Are there disadvantages? Definitely. There are also disadvantages. When a company is formed, those people who form the company, they are covered. They are covered by something imaginary something you can imagine. It is not real, but we imagine in law. They are covered by what we call the veil of incorporation. You know what a veil is?
No.
When a lady gets married, when we go for her wedding,
Yes.
she dresses in a very nice gown and she puts some cloth on her face. That cloth covers the face, even though she can see us and we can see her, but not very clearly. A very nice cloth. That cloth is what we call a veil. So it covers you halfway. You can see through, we can see through, but it's not very clear. And then when the pastor or the priest says, you may kiss the bride, what happens? The man removes that veil and he kisses the bride. So he removes it and kisses it. Now, the veil of incorporation, in law, we are saying that when a company is formed, that piece of cloth, it is imagined, it is not real. That piece of cloth covers the human beings who have formed that company. So we do not see them. All we can see is what? The company. If Peter, Mary, John, and Rukundo form Company Alpha, we will not be able to see Peter, Mary, John, and Rukundo. We will only see Company Alpha because Peter, Mary, John, and Rukundo have been covered by the veil of incorporation. Okay? However, if the company commits an offense, if the company breaks the law, then what is going to happen is the office of the registrar will remove that veil. And when they remove that veil, we can now see Peter, Mary, John, and Rukundo. And what is going to happen? Those people are now going to be personally responsible. So it is a very simple principle. We will discuss it, we'll understand it, and we shall look at examples. The veil of incorporation.
Yeah.
Okay.
In Kinyarwanda, we say umutaka.
Umutaka.
Yes.
Okay, sawa, thank you. Next, chapter 2, formation of the company. Now, with formation of the company, we need to look at the various procedures, the requirements expected of us when we decide we do not want a sole proprietor, we do not want a partnership, we now want a company. When we talk about forming a company, there is a word we use. The word is called promotion. Promotion. It comes from promoters.
Come again, lecturer.
Formation of a company. We need to know what is required in order to form a company. All that we know now is, yes, it must be registered. Sawa. What are the procedures of registration? What are the requirements of registration? So, when we talk about formation of a company, we use this word promotion. Yes, legally, formation of the company is the same as promotion of the company. Okay? Now, this word promotion comes from the word promoter. A promoter, who is a promoter? Tell me who is a promoter. Somebody, there is something good about law. You can use a word to explain itself. Example, who is a promoter? A promoter is a person who promotes. Sawa, it will be correct. But now the problem is, what do you mean by promoting? So can somebody tell me who is a promoter?
Shareholders.
A person who comes with the idea of forming a company. Somebody else has said shareholders. What do they want their company to do? What name do they want to give the company? Which place do they want the company to operate from? Who is going to be in charge of what? We talk of a manager there, etc. And then most importantly, they are the ones who must organize to present certain documents to the, yes, please.
The meeting is keeping ending after 40 minutes. Is for me only or?
No, it is for all. It is for all. It is for all.
Oh, okay.
Yes, but when it ends, just knock back. I will put you back in like that. So these guys, they are the same people who must ensure. They must ensure that certain documents are written in the required manner and they are presented to the ORG, Office of Registrar General. The documents which are presented to the Office of the Registrar are what we call the constitutive documents. The documents presented to the registrar are the constitutive documents. Constitutive comes from the word constitution. So, the constitution of the company is simply what? The memorandum of association and the articles of association. Bas. So, in this chapter 2, formation of the company. Formation of the company, legally we say promotion of the company. Promotion because it is by the promoters, the people who develop an idea to form a company and to do business and to share the profits, etc., etc. These people will do many things, including getting the name of the company, getting the assets of the company, knowing what business the company will do, and then registration of the company at the Office of the Registrar. The memorandum of association and the articles of association are the constitutive documents. They are the constitution of the company. The difference between the memorandum of association and the articles of association, we are going to understand. We are going to realize that memorandum of association is the main document of the company. It is the document which shows the raison d'être of the company, the reason for existence of the company. And all companies must have this document. It is inside this document that we shall have the objects clause. The objects clause is the one which talks about what? Ultra-vires. So if we say our company will be making amandazi and then we start manufacturing cars, we have gone against the memorandum. It is ultra-vires. What we have done will not be the obligation of the company. It will be our personal responsibility. Apart from the memorandum of association, we have articles of association. Articles of association is a secondary document of the company. And the Companies Act tells us that a company may or may not have articles of association. So if you want, you can have articles. If you don't want, forget about it. But the Companies Act says, if you don't have the articles, the Companies Act will be your articles. Yes. If you want, you can have your articles. If you don't want, don't have the articles. But if you decide you don't want the articles, the Companies Act becomes your articles. So legally, we advise those who want to form a company, we advise them to do what? To write their articles. Because if you are going to allow the Companies Act to become your articles, you are imposing a lot of obligation on yourself. Okay? So we're going to look at the details on that. And it is not a big deal. Then move on to chapter 3. With chapter 3, we are now looking at membership. Before I proceed, remember, at every stage, from chapter 1, we shall be looking at the study material, the Companies Act, the leading cases, the question papers. We shall be looking at all that. So it's going to make a lot of sense. Let us just have faith, all shall be well. Membership of the company. Now, we have said promoters are the ones who decide to form the company. Eventually, some of us will come and find the company is already there. We want to become members. It is like you find the Ritiko bus has left Nyabugogo. It is going to Musanze. And then you get the Ritiko bus after Nyabugogo. You get the Ritiko bus after Nyabugogo. It has already been people have already entered. So you want to become a member of that bus and go with it. So we look at how does a person become a member. This is where we talk about what? Acquisition of membership. Acquisition of membership. The first way by which a person becomes a member is by subscribing and buying shares, and you become a shareholder. And then there are so many other ways by which you can become a member. You can become a member because the person who was a member was your relative, your brother, your sister, your mother, and that person died. So you inherit that membership. You can become a member through many ways. Apart from acquisition, we also have cessation. Cessation is the opposite of acquisition. Cessation is ending. You can decide you don't want to continue with Ritiko to Musanze. You want to alight. So you get to, where do you call this? Where we have Sina Gerard's shop. It is called where?
Nyirangarama.
You get to Nyirangarama and you say, I don't want to continue. I will not go to Musanze. So cessation of membership is also allowed. You can decide to offload your shares. Alternatively, if unfortunately you die, your membership comes to an end. Your membership comes to an end because there is no law which says the company has dead members. You cannot have dead members. When you are dead, you are gone. You become a member of another place. If you are like me, you'll become a member of heaven. If you are not like me, I don't know where you'll become a member of that other place we fear very much. So cessation also comes in many ways. A person can surrender his membership. A person can transfer shares, etc., etc. We're going to look at all this. Now, I believe all of you are religious. Many of you are Christians. Many of you are Musliman. When you become
Christians.
a member, yes.
We are Christians.
You are Christians.
Yes.
But I also have my friends there who are Musliman. Sibyo?
Maybe.
Saying maybe. Yes, they are. Rwanda allows Christians and Musliman. Even Hindu. You know Hindu?
Yeah.
The Indians. Rwanda allows all religions. Now, when you become a child of God, we say you become a member of the family of God. I am Roman Catholic, and we say we are Familia Dei, the family of God. Okay. Now, when you become a member of a company, then you must be having some rights. When you are a member of the family of God, you have certain rights. You are a child of God. You are protected. So, a company gives membership to a person and that person acquires certain rights. The rights of this person, briefly, because we don't want to go into detail, we shall go into detail when we'll be discussing the entire notes. We have individual membership rights. You as an individual, you have certain rights which are just for you. Not even for your brother or your wife or your sister. No, just for you. Your individual membership rights include your right to vote. Your brother will not vote for you. It is you to vote. Your right to get dividend when a dividend has been recommended and declared.
There are some people make noise. I don't know.
Hey, those people who are making noise, please, you are disturbing the class. I can identify them here. Jerome, you are disturbing class.
Yes.
The other one is innocent.
No, I was cleaning.
You're okay. Another one is, let me see another one disturbing the class here. Okay, so when we are members, we acquire those rights: the right to vote, the right to attend meetings, the right to dividend. Apart from individual membership rights, we will also realize that we have other rights, which we call corporate membership rights. Corporate membership rights. That, you see, you as an individual in Rwanda, you have the right to be protected by the government of Rwanda. Okay? You as an individual, not even you and your mother. No. You as an individual, you have a right to be protected. Your mother as an individual, right to be protected. Your brother, like that. Apart from that, we have corporate membership rights. Now, corporate membership means now all of us as Banyarwanda, we are now corporate. Yes? Individual is you as Uwamaria. Corporate is all of us as Banyarwanda. So individual is different from corporate in the sense that it is now the members of the company have the rights as members of the company. When do we look at this corporate membership? We look at them basing on what? Majority rule. That corporate membership is identified by looking at what does the majority want. Okay? Corporate membership is identified by looking at what does the majority want. Corporate membership and the majority are simply what we call democracy. Democracy.
Yes.
That when we are in a company, you have a right to vote, I have a right to vote. Those are our individual membership rights. But then, your vote alone will not be useful unless we look at numbers. So, you should convince other people to vote with you on the same side. It's just like when we go for elections. It is elections now. We want to get new deputies. Yes? Now, even though I want to vote for Pierre to be our deputy, it is my right to vote for Pierre. The problem is, how many of us are going to vote for him? So, each one is voting for somebody, but now we're going to look at the democratic, the majority. If majority vote for Pierre, the guy is lucky. Then he becomes the deputy. So, with the membership rights, we are also going to look at the majority rule. The majority rule is simply the democratic principle. The principle which says that decisions in a company are made based on majority vote. If we are 10, if 6 say yes, the company has said yes. The remaining 4, let them wait for next time. Okay? Now, there is only one problem. Yes, democracy is good. Do you like democracy? Tell me something. Do you like democracy?
Yes.
You like democracy. Why do you like democracy? Yes? Why do you think democracy is good?
Combining ideas.
Combining ideas. So it is not one person's idea, it is idea of many persons. Sivyo? Okay, sawa. In government, okay, please understand this. In government, democracy is very good. In government, democracy is very good. Like what happens in Rwanda, it's about democracy. It is very good in government. But when we come to companies, democracy can be good and it can be bad. Why? Yes, the majority can say, let us start a new project in Nyagatare. So the majority have said, let us start a new project in Nyagatare. That is good. But again, it is possible. The majority can be very greedy and they want to do things which will only benefit them and cause problems to the minority. So in companies, sometimes majority is dangerous. And that is why we're going to look at what? Majority rule and minority protection. The minority in the company must also be protected. You see, the fact that out of 10, 7 of you said yes, and 3 of us said no, does not prove that the 3 of us are wrong. Sivyo? Sometimes we may be wrong, we may lose the war. We may lose the war, not because we are wrong, but we lost it because the majority have been influenced by the directors. They've been given some benefit. So in companies, we realize that majority rule, democracy is good, but sometimes it's dangerous, and that is why we have the rule in force versus habitual. So we're going to look at the rule in force versus habitual. The rule in force versus habitual is simply what? The majority rule. Okay, we shall discuss that. And this force versus habitual is one of the 17 cases. Sawa? Any questions so far? What we are doing, I'm simply giving you a brief of what we expect. Brief of what we expect to encounter. Okay. Then the next, chapter 4, look at shares. What in your understanding is a share? What is a share?
It is a contribution given by those people who comes with the idea to create a company.
Contribution given by those people who come with ideas to create a company. So a share is what you bring into the company. What you bring into the company becomes a share, and for that reason, you end up owning. You own a part of the company. Sivyo? You own a part of the company basing on what you have given the company. If you have given the company 100 million Rwanda franc, then legally we can say you own the company to the extent of 100 million. Okay? So shares are simply a unit of capital. Shares are a unit of capital which shall be measured. It shall be measured by the contribution a member has given into the company. A unit of capital measured by the contribution a member has given into the company. And we're going to realize that shares, they do not always have to be, they don't have to be mafaranga, they don't have to be money, but they are measured in monetary terms. Example, when joining the company, we may agree you bring 100,000 mafaranga, you bring 1 million mafaranga, and you bring the 1 million mafaranga in cash. At the same time, Peter wants to join the company. But Peter does not have mafaranga in cash. Peter has a motto. Peter says, I don't have 1 million mafaranga, but I have a motto. I want to give this motto to the company as my shareholding. So shares can also be in form of what? An asset, whether movable or immovable. For Mary, she has given 1 million mafaranga in cash. For Peter, he has given the motto. That is an asset, a movable asset. And then there is a Jonas here. Jonas does not have cash, does not have asset, but he is one of the best accountants we have in the country. Jonas says, I don't have money, I don't have an asset, but I have skills. I will contribute into my shares skills. So he says, I will work for the company as the accountant or as whatever he's going to work as for a particular period. And then we quantify. A person who has qualification like this of Jonas, how much is he earning every month? Okay, sawa. Multiply by how many months or years is he ready to work for the company? So when we multiply, we find 10 million or 20 million, whatever it is, that becomes his share. At the end of the month, he does not get the salary. Instead, that salary is, we open an account. That salary, at the end of the month, is put into his share account every time like that. So we're going to look at that. There are various ways by which we can get our shareholding. Then, another thing is, there are various classes of shares. What do you mean by classes? Classes, we mean types. There are various types of shares. Briefly, all of us know, as accountants, you know, there are some shares. Give me an example of shares, types of shares. Yes? Mention some 2 types of shares you've heard of, you've known.
Yeah, sure.
Yes? Sawa. Ordinary shares, Preference shares, sawa. So you find we are going to identify that there are various classes of shares. Ordinary shares, preference shares, deferred shares, employee shares, management shares. All companies, all companies must have ordinary shares. All companies must have ordinary shares, whether we like it or not. However, there are companies which may also decide to have other types of shares, e.g., the preference shares, the deferred shares, management shares, employee shares, founders shares. So we're going to look at all these types. And then, just as we say, because you are a child of God, you have certain rights. Because you are a citizen of Rwanda, you have certain rights. And you also have what? Obligations. So likewise, the types of shares also give you certain rights. They give you certain rights and they also give you obligations. Shares also give you obligations, including the obligation to pay up unpaid shares. And then we have said a person can become a member and a person can end membership. When you're talking about cessation and acquisition, you can become a member and you can end your membership. Therefore, we also have here transfer of shares, which means I have 1 million shares, I can transfer 500,000 of these shares, I can transfer all the shares. So shares can be moved. Shares are movable property. They can be moved from one place. They can be traded. Okay, so there is transfer of shares. Transfer, the owner decides to dispose them. The owner directly decides to dispose, to give them, whether for consideration, whether for cash or for free. He decides by himself. Transmission, the owner does not decide. Transmission happens automatically because of two things. Number one, because of death. If I am a shareholder of Bralirwa and then I die, my shares transmit to my dependent. But if I'm a member of Bralirwa and then I want to sell my shares to Peter, then it means I transfer. So transfer is I am giving out. Transmission is I am dead. When I die, automatically they go to that other person that I have mentioned in my record. Apart from transmission by death, transmission is also by bankruptcy. That I have become broke. I am unable to pay my debt. The shares transmit. Okay. Then we have said shares are movable property. Shares are tradables. They are tradables. Therefore, I can use my shares to get a loan. I can use my shares to get some money from Becca, from Peter, from whoever. I can use my shares to get a service. And then I will pay back. Therefore, we have mortgage of shares. When you talk about mortgage, we are talking about giving your shares in return for money. Your shares in return for money. Or in return for a service. There are procedures. We are going to look at those procedures. Mortgage is of two types. We look at the details of that. We have legal mortgage and we have equitable mortgage. Legal mortgage, equitable mortgage. We shall see the difference there. Okay. Then, when you go to buy shares from Company Alpha, the company will tell you, Sawa, you wanted how many? I wanted 1 million, Sawa. We have 1 million shares ready for you here. Now, you don't pay for all of them immediately. If you have the money, you can pay immediately, no problem. But normally, you don't pay for all immediately. Instead, you'll pay the required deposit. There are terms and conditions. So you pay the required deposit. Once you have paid the required deposit, then Company Alpha will tell you, Sawa, you have paid the deposit. The 1 million shares that you had applied for, they are here for you. They are here for you. The word we use in law is they have been allotted. They have been allotted to you. Okay? So an allotment is the behavior where the company sets aside a specified number of shares for a specified subscriber. They have kept them aside for you. You have not started paying. They have kept them aside for you. They have allotted. That is an allotment. Okay? Now, after they have allotted these shares to you, the next thing is going to be that after every period of time, whenever the company wants money, the company will tell you, hello, Maria, we want you to pay for this number of shares. Then you pay. After another period, maybe several months or 1 year, Maria, we want you to pay for another number of shares. Yes? I think the problem is with your machine. Just check your machine, please. So after you have been allotted the shares, what you are saying is, after you have been allotted the shares, the company will now be telling you, come and pay for this, come and pay for this, come and pay for that. The company will be making a demand so that you start paying and you start reducing. 1 million you are given, you start paying. Now you still have 900,000 to pay, you have 600,000 to pay, you have 200,000 to pay, you have paid everything like that. The behavior of the company telling you come and pay is what is known as a call. So a call is a demand by the company telling a subscriber to come and pay for a certain number of shares. Okay? So today, come and pay for 3,000. Come and pay for 4,000. That is a call. They make a call. And when they make a call, you must respond by paying. If the reaction will be, the company will have the right of forfeiture. Forfeiture means the company will take away those shares and give them to somebody who's ready to pay. So we shall look at that detail. Now,
Please.
Yes.
The prospectus and the
No, not yet. We are not yet. We are not yet there. We are not yet there. Not yet.
Okay.
Yeah. So allotment, we have said they have put aside 1 million for you. They tell you these ones are yours. Nobody else will take them. These ones are yours. They are safe. But then there is a condition. You must come and pay for them. You must come and pay for them. So the 1 million has been set aside for you. You must come and pay for them. They tell you come. It means a call. They make a call for you to come and pay. Okay? Now, because you have shares, you expect a return on those shares. Why did you take shares in the first place? You took shares because you are expecting something. You didn't take shares because you took shares. No. You took because you're expecting. We are good people because we expect something. We are not good because we are good. No, we are good. If your pastor or your priest has never told you, let me tell you, we are good people because we want to go to heaven. Not because we are good. No. If there was nothing for us to be good, we would not be good people. Now, you take shares because you expect something. If there is nothing you expect, you will not take those shares. The expectation on the shares is what we call a dividend. Dividend is the return on your investment. Dividend is the return on that share that you have bought. Okay, and we're going to look at dividend when it is recommended, when it is declared, and who does this. Okay, it is one of your rights as a member, one of the membership rights, the right to dividend. Okay, then my friend is asking prospectus. This idea of telling the public, we are forming company Alpha, our company will be manufacturing motors and spare parts of motors and selling them in Rwanda and East Africa. How do we tell the public our company will be doing this, our company will be doing that? How do we tell the public we want the public to come and buy shares? We tell them by writing a document known as a prospectus. So a prospectus is the document which is written by the company management telling the public, this is the type of business we want to do, this is the amount of money we need, these are the number of shares we are going to give you so that we get this money. Prospectus. It is an invitation to the public to come and buy the shares or debentures of the company. And the prospectus has certain requirements. In order for it to be valid, there are certain requirements we are going to look at. It must contain the truth. If it has any statement which is kubeshia, we are finished. will be taken to court. Okay? So this is chapter 4. Talking about shares, the classes of shares, how they can be transferred, how we can use them as security, how does the shares dividend, what document is given to the public to tell them that we are doing business and we want money, prospectus. Okay. We shall look at the details on that. Then chapter 5, we go to share capital. Now, let me start by saying this. When we are forming this company, we are looking forward to making money, profit. Actually, the Companies Act tells us, we're going to look at this. The Companies Act tells us that every company formed in Rwanda is formed for commercial purposes. The Companies Act tells us that every company formed in Rwanda is formed for commercial purposes. Even if the business we are forming is not for purposes of making profit, e.g., if you are talking about Red Cross and Red Crescent, if you are talking about, there are many businesses which are there just to help the baturage. The law says, Sawa, you write that one in the memorandum, but what we know is a business is formed for commercial purposes. Now, how does a company get money? What are the ways by which we can generate revenues in a company? Can somebody tell me? You as accountants, definitely you know. How do we generate revenues in a company? There are three. Yes?
Okay.
Yes, please. Through its ordinary activities. Which means through its ordinary activities. So you're saying if it is manufacturing and selling motors, the profit, Silvio, the profit it will make. Sawa. So one of the ways by which a company makes money is through profit. Okay. Any other way by which we make money? How do we get money? One, we get money through profit. Another way we get money? Sawa. Issuing shares to the public. That sometimes we may be having a problem in starting that business because we need money. So let us give this opportunity to come and buy part of the company. In return, they give us the capital. They become shareholders and they give us a capital, which will be share capital. So share capital is a capital from the business that will give us a profit. We tell the Baturage, come and buy shares. The money we get from the sale of shares is share capital. Capital generated from the sale or issuance of shares. Okay. When we give out these shares, there will be various types of share capital. There will be various types. That first and foremost, there will be various types of share capital. In the time we are forming the company, we will have to write in the memorandum and articles the initial amount of capital that we are hoping to raise. We are now forming the company now. We are the promoters. We must write in the memorandum and articles the beginning level of capital. The beginning level, the start level of capital is what we are going to call the registered capital. It is the one we register the company with, registered capital. So when we talk about types of share capital, we shall look at quite a number of types. There are about 9 types. Registered capital is the capital we form the company with, the one which we write in the memorandum and articles. It is also known as the nominal authorized capital. Registered capital or nominal authorized capital. Then, let us say the registered capital is 100 billion. We do not want to give the Abaturage an opportunity to pay for all this now. No, it is in the course of time. Because remember, a company is a going concern. A company is there for the unforeseeable future. So for now, out of the 100 billion, we can say, let us give the Abaturage 30 billion. We tell the Abaturage to come and buy shares worth 30 billion. Okay? When we tell them, come and buy shares worth 30 billion, we are using the prospectus. We tell them, come and buy shares worth 30 billion. This one that we're telling them, come and buy, is what we now call issued capital. Issued capital. We have given to the public issued capital. Or allotted. Issued or allotted. We have given the public, buy this one. We are remaining with 70 billion we have not touched. The 70 billion we have not touched is what you're going to call an issued capital. Out of the issued capital of 30 billion, people have taken 30 billion. We now tell them, now you people, out of this 30 billion, we have allotted you. We want you to pay for 5 billion. So out of 30 billion, which we have issued, we have allotted, we want them to pay for 5 billion. The 5 billion we want them to pay for is what we're going to call what? We're going to call called up capital. Called up, because you have made a call. Remember what we said a call is. So out of 30 we have given them, we have called for 5. We want them to pay today. No, okay, not today. We want them to pay within the 14-day period. Called up is what we want to pay. They come and pay for the 5. Which means there is a 25. We have not called up. So the 25 is there for what? And called up capital. We are going to realize, my friend, the types of share capital are very simple. You just pick the opposites. Issued capital and issued capital. Called up capital and called up capital. And then out of the called up, there are those who are going to pay. When they pay, it is paid up capital, the one which is not paid, and paid up capital. Like that. Very simple, straightforward. By the way, company law is very interesting. Have faith, just be attentive, ask questions, everything is straightforward. And then, it is also possible, we can say, remember there was 70 billion. There was 70 billion which we have not given to the public. We can say, out of the 70 billion, let us put aside 10 billion. We should not talk about it. 10 billion, forget. So in the future, if we want more capital, let us talk about 60 billion. 10 billion we have put aside. That 10 billion shall be the reserve capital. We can say that is reserve. And so on and so forth. Eventually, we will also have another type of capital, which we are going to call debt capital. Debt capital, which is simply what? Capital from borrowings. Capital from borrowings. Why would a company want to borrow? Can you give me reasons why a company wants to borrow? Why does a company end up borrowing?
Please, lecturer.
Yes.
I do not understand flotation. What means flotation? Alteration of share.
Okay. Flotation. When we talk about putting shares on the market, yes,
Okay.
putting
Yes.
shares on the market. It's like when you have a birai, or you have a mandazi, or you have a bitunguru, you are taking to the market. You want people to buy. You know, you must put those bitunguru or birai at a place where people can see. Strategic.
Yes.
Hey. And if possible, the place should be nice, clean, so that people come and buy from you and they don't buy from the other person.
Yeah.
So flotation is the process of presenting shares to the public for purposes of buying. Yes? Flotation.
Yes.
Hey. Now, this is where now we talk about direct offer, those types of offers that you are telling the public come and buy, to buy shares. That is the element of flotation, presenting them to the public through prospectus. Okay? Sawa.
Then alteration of share.
Alteration. Now, you see, today we are all very healthy. All of us are very healthy and we are in class. We do not know what tomorrow has for us. Tomorrow, one or two of us may become sick. Tomorrow, one or two of us may win Tombora and become very rich. Tomorrow, one of us, a thief, may steal his money, his property. So life is uncertain. Therefore, in a company also, we have these uncertainties. The rule in Trevor versus Whitworth says that the share capital of a company must remain constant. We must know what is the share capital of the company, 100 billion, sawa. It must remain constant so that the investor is safe. The investor knows, I've invested in company Alpha. So in case there's a problem, they will pay me. That is the rule in Trevor versus Whitworth. However, this is not possible in life. There are ups and downs. Look at Corona. Corona has brought many big businesses down. And so many other unfortunate things which happen in life. Poor management, etc., etc. So, alteration of share capital, this structure, the structure that we have talked about, where you have the registered capital, you have the called up, etc. It is possible because of the ups and the downs, we end up reducing the nominal authorized capital, the registered capital. We have talked of our registered capital being 100 billion. We want to reduce it because we have problems. We cannot manage to remain at that top level. If you are living at Kachiru or you are living at Chimihurura because your finances were good, your job was good, but life is funny, then something unfortunate happens, my friend. You can no longer continue living at Kachiru. You can no longer continue living at Chimihurura. You will have to look for a cheaper place where you can afford until things come back to normal. Then you'll go back to Chimihurura. So alteration of share capital happens where the company, through the board, calls the members and they tell them, now, our registered capital was 100 billion, but we want to reduce it. You know, registered, it means it is written in the documents at the office of the registrar. In order for you to change that figure, you must follow a procedure to go and change it at the office of the registrar. And then, we have said a company is managed through what? Democracy. So people must vote, a special resolution, etc., etc. That will be the alteration. Alteration will connect with the raising and the maintaining of capital. Alteration will not only be bringing the capital down, it can also include increasing. So this Trevor versus Whitworth story will connect with the raising and maintaining of capital. We are going to look at the ways by which the company can have a meeting and pass a resolution to raise and maintain, to alter the capital of the company. One thing is, if you want to put a liability, on a member. You want to tell a member to take up more shares. The law says the member cannot be forced to take up more shares unless he accepts in writing that, yes, I will take more shares. Because it is an extra obligation on the member, even though he will get more dividend later, but it is an extra obligation. So there are rules and regulations which will show us matters concerning this alteration of capital, raising and maintaining of capital. All these things go together. Now, share capital is the capital from shares. The other capital will be from profit. But then it is possible that the company can simply borrow. Why does a company borrow? Give me 2 reasons why a company borrows.
To pay credit. To pay credit. The company has a debt, so it wants to clear that debt. That is one. Another way, okay. That is the main way, by the way. That is the main. Another one? To expand activity.
To
expand activity.
To expand its activities. It is short of finances, so it wants to expand, open up another branch. Another one?
It is a requirement so that they can have
yes, they can have
a balance in leverage.
Balance in leverage. Okay, sawa. Sawa. Now, it is possible that the company needs money for any one of those 3 reasons you have given me. Very good reasons. The company needs money. But why don't they want to get money from shares? Yes? Why can't they sell shares and get that money? Why don't they want to do that? The leverage, the clearing of debt, expansion of the business. Why can't they sell shares and do those things? Yes?
The source that are lower.
Resources are lower.
No. I sometimes if you are going to look for the money to invest, sometimes you look for So debt may be the source when it comes to cost of that capital.
Okay. Now you are talking like an accountant. Sawa. Okay. Yes. Anybody else? Just 1 minute. 1 minute.
Because shares becomes a capital, and the capital have financed the asset of a company. So
okay. Sawa. Now, the idea that we give shares to the public is good, but it also has one problem. Remember, when Peter becomes a shareholder of Company Alpha, Peter will acquire certain rights, including the right to vote. The right to vote is a very dangerous right because Peter will start making decisions. He will convince other people and they will come as majority and they'll start making decisions. The company management, the existing management, is never comfortable when there is a new team of people suddenly coming into the company, buying shares and having a lot of power. Look at what is happening in some of these football clubs, like my favorite, Arsenal. Some of the decisions the management of Arsenal makes are very bogus decisions. Because instead of buying good players, instead of increasing the wages of the players, they just do their own things because the management, the top management, has made its decisions. Why? Majority shareholders. Majority shareholders. Kroenke and such other people. They make very unpopular decisions. When we allow more people to come and buy more and more shares in the company, we are giving more power to the shareholder and reducing the power of the management, such that you may find there is a majority shareholder. Majority shareholder, he will start dictating what is to be done. That is another reason why a company can say, yes, we need money for leverage, we need money for expansion, we need money to clear debt, but let us not get this money from shares. Also, if you want to get money from shares, you don't get that money immediately. It takes time because prospectors must be prepared. Then there's the allotment process. Then you must make call. When will you get that money? It will be after a long time. And sometimes you want money as an emergency. So the company says, we don't want people to become majority shareholders and take away the powers of management and start dictating what we should do through voting. Let us go to Beka or Koje. Let us tell them we want 100 billion. They will give us 100 billion? Yes. We shall pay back plus interest. Our relationship with Beka will be what? Creditor, debtor, nothing else. They cannot dictate how we are going to run our business. So that is one other reason why a company decides to borrow instead of getting money from share capital. That is the debt capital. Debt capital is also known as loan capital. Debt capital, also known as loan capital. And one reason for debt capital is we want to expand. Another reason, the leverage my friend has talked about. Another reason, to clear debt. And then the other reason, all these three, we need money, yes, but let us not get it from the Baturaje. Let us get it from a financial institution. When we talk about debt, the powers of borrowing in a company are handled by the board of directors. Individual members cannot borrow on behalf of the company. It must be the board which borrows on behalf of the company. The board must only borrow for purposes of the company and not for the wedding of the executive director. Not for the purchase of a new Prado for the finance director. So it must be for the benefit of the company. The powers of borrowing. Borrowing must be within the limits which have been specified in the Articles of Association. The Articles of Association will provide the ceiling, the limit within which a company can borrow. Now, when these people borrow, they must borrow from legally recognized sources. They must borrow from financial institutions. Is it Koje? Is it KCB? Is it Beka? Is it Equity? They must borrow from such institutions. You don't go and borrow from some funny person at Nyabugogo for the sake of the company. That one will be the responsibility of the specific directors who are borrowing. There are these guys behind the street. You don't borrow from such people. It is against the law. Borrow from legally recognized sources. Now, because they have the power to borrow, automatically, they also have the power to give any of the assets of the company as security. So if the company has power to borrow 500 billion, the company will have automatic power to give any of the assets of the company as security for the 500 billion. When we talk about debt capital, automatically, we talk about debentures. When you talk about debt capital, we talk about debentures. What is a debenture? A debenture is simply a loan. A debenture is a loan. Okay? So when Toyota Rwanda borrows from Beka, that is a debenture. And Toyota Rwanda will give some of the Toyotas and some of the buildings as security. Those buildings, those Toyota Prados, they are the charge. So a debenture is the loan, a charge is that security. Okay? A charge is the security on a debenture. A company Alpha has taken 100 billion and it has given its building as security. 100 billion is debenture, building is charge. The other meaning of debenture, apart from debenture meaning a loan, the other meaning of debenture is what? The document itself. The document which confirms we have borrowed from Beka. That document is also called debenture. And it is a cash equivalent. It is a tradable security, a debenture. It is a tradable security. That is why, if you remember, we said the company has power through a prospectus to give shares and debentures to the public. Shares and debentures. So a debenture is a tradable. A debenture is a loan. A debenture is the document which shows the loan, and that document shows the equivalence of the value. Okay? We shall look at the types of debentures. Yes, please.
Please. In other words, charge is a mortgage.
No. I will explain that 1 minute. That is another story we need to get to. Now, a charge is security. A charge is collateral. A charge is collateral. A charge is collateral. So, our company has borrowed 100 billion from Beka. Beka tells us, Sawa, take this 100 billion, give us security, give us collateral. We tell Beka, take this building in Musanze as security, or take these 3 Prados as security. This security, this collateral is the charge. A debenture is the loan, a charge is the collateral. Now,
I think it is the same of mortgage. We give when we apply for the loan.
Okay. I will explain. I will explain the connection with the mortgage.
Yes.
Now, this charge, which is the security, this charge, which is the collateral, it is either fixed charge or floating charge. Okay? A charge, security, it is either fixed charge or floating charge. Fixed charge is the security or the collateral which shows specific assets have been actually taken by the lender. So they have taken the house, they have taken the motor car, they have taken the refrigerator, they have taken the television. Fixed is an actual asset. Whether it is movable or removable, it is a fixed charge. Okay? And the borrower gives the title documents to the lender with a fixed charge, and the lender is in control of that asset in a fixed charge. A floating charge, the borrower still has his assets. His assets are not given to the lender, but the lender has seen the assets. The lender tells the borrower, Sawa, you take the money. The lender can still use the assets. The lender can even sell the assets and bring other assets. There's no floating charge. Floating charge only comes where the lender is satisfied that you will pay. The lender has a good relation with you. The lender is comfortable. Maybe through experience with you. Maybe the lender also sees your portfolio. You are worth 300 trillion and you're only borrowing 1 billion. They'll just give you with a floating charge. But a fixed one, they have the asset. Okay. Now, let us come to my friend's question. When we talk about debentures, we are talking about a company borrowing money from a financier and giving the company's assets as security. Debenture, it is for the company borrowing and the company giving assets of the company. Debenture. When we talk about mortgage, it is the shareholder giving his shares for a loan as security. Okay. Yeah. Okay. That is the difference.
Thank you.
Sawa, karibu. Now, remedies, we are going to look at remedies. When Company Alpha has borrowed money from Becca and they are not paying, what will happen? There are many remedies. Becca will go to court and say, this property is going to be sold. Becca can go to court and say, okay, we don't want to sell this property, but we want to manage it. We want to manage it so that we get the monies collected from the business. After they have paid us, we give back the property. If Becca does that, that is what we call appointment of receiver. Okay? Appointment of receiver, I do not want to sell your property. Instead, what I want to do, I want to manage your property, pay myself from the revenues, and then give you back your property. Appointment of receiver. It is a better way of dealing in business than winding up. Winding up, insolvency, sell that property, get your money. So we're going to look at the remedies, and there are quite a number of them. Okay. Now, is it okay if we can take a break now? It is 3:30. Is it fine we take a break? That we can drink some amazi?
Yes.
Until what time? Until we take half an hour? How much time can we take?
Half
hour, okay. So we come back approximately 4 o'clock. We come back 4 or 5.
4 or 5.
Okay, we come back 4 or 5. We continue up to 5 o'clock, and then we see what else we can do. Sawa, that's fine.
Okay, thank you.
Okay, welcome.
Thank you, sir.
For purposes of the company, it must be borrowed from legally recognized sources. Now, remember also, the link that you have to our class, It is the same link we are going to use next time. So that we don't confuse, like what has happened, Sasaba, there was mix up. If we use one link and continue, it is better than next time we change. So this is the same link you're going to use. Just remember that. We move on to the next. Meetings, the law of meetings. Now, it is important for us to know that the only way the company can discuss business of the company is through meetings, whether it is of the board or it is of the board and the members, or it is of the company and the debenture holders. It is through meetings. Can somebody tell me what you understand by the word meeting? What is a meeting? In your understanding, what is a meeting? Have you ever gone for a meeting? Yes? Anybody? Have you ever attended a meeting? Any meeting?
Yes.
It is a conversation.
A meeting is a conversation
between one or more people dealing some line that can help us to achieve the goals.
Okay, between one or more. Yes.
Yes.
One person can have a meeting.
Not two or more people.
Okay. You know, okay. When you wake up in the morning, most of the time, you have a meeting with yourself. You start thinking, what am I supposed to do today? Where am I supposed to go? No, I will go here first, then I'll go there. Yes, I did. So sometimes you can have a meeting with yourself, but it is not really a meeting. So a meeting must have at least two people. Yes, there must be at least two people sharing some communication. Now, a company, the business of a company is decided through meetings. So meetings are very important in the life of a company. First and foremost, we need to understand the definition of a meeting. And the definition of a meeting is found in the rule in Sharp versus Deus. The rule in Sharp versus Deus tells us exactly what I have just asked, that there can be no meeting of one person. A meeting must have at least two persons, minimum two persons, so that there is that conversation. That is the basic rule. But now, when we start discussing it in detail, we realize that we are told a meeting is that which has a quorum of members. A quorum of members. What is a quorum? There is another document which I forgot to show you. There will be a document which I will be sharing with you every time. I call it the whiteboard. I call that document the whiteboard because I will be using it to write things. You know, sometimes when you speak, there are some words which cannot be very clear. You need to write them, like the spelling, so that somebody can understand. So on the whiteboard, like now, 1 minute, I will be writing some words, some statements, even helping to answer some questions as we proceed. So we are saying, with a meeting, we are saying it must be a quorum of members to discuss the business of the company. Okay? Quorum of members to discuss the business of the company. Now, what do you mean by this word quorum? What does the word quorum mean? Quorum means
the number of participants invited for the meeting.
Number of
the member of the meeting or the participant, the member of the meeting.
Okay, sawa.
For the meeting to take place or to go.
Okay, sawa. So a quorum is a minimum number of members to make a meeting legal. Okay, now a quorum, like football, quorum is what? Quorum is 11. You need 11 to start the game. A quorum is decided by the company itself. There is no standard quorum. Each company will have its own quorum. Okay? Quorum is written in the Articles of Association. Quorum is written in the Articles of Association. Inside quorum, we find what the company has decided as the minimum number. So company Alpha may say our quorum is 15. Another company may say our quorum is 3. Another one is 10, like that. So in order to have a valid meeting, that meeting must have a quorum. It must have the minimum number of members. And under normal circumstances, the minimum number is not less than 2. Okay. However, there are exceptions. We are going to realize that in company law, the rules are very strict. But the funny thing is, all the company rules have exceptions. All of them. They tell you this is the rule in Sharp versus Deus, the rule in Solomon versus Solomon. However, there are exceptions. Okay? Now, there are exceptions where a meeting can have one person. You can have a meeting of one person. And it will be a valid meeting. You meet with yourself and legally it is a valid meeting. The example is this. When you look at the Companies Act 2021, there is something interesting you are told that one or more persons can form a company. One or more persons can form a company. This means you as Pascal or you as Maria, alone as you are, you can form a company. Now, a company must have company meetings. Who will you have the meeting with? You must have the meeting with yourself. So where the company is formed by one person, and it is only that one person who's there, that one person can hold a valid meeting because that one person will be the quorum. Number two, even where a company is formed by more than one person, let's say 10, 20, 30, but the company has only one director, because we are told private companies can have minimum one director. So if your company has only one director, the law says a company's board must have board meetings. This one director will be the board, and this one director will be having a meeting with himself. So we are going to look at, actually there are 6 exceptions where one person can hold a valid meeting. If it is not any one of the 6 exceptions, that meeting is not valid, that meeting can be thrown out by the court. Now, Inside a meeting, there are elements. There are things which are expected to exist so that the meeting is a meeting. Remember, the board should have a meeting. The company itself, that is the board and the general meeting, should have a meeting, the members. Then you find that in the company, there will be many members having different types of shares. Members having a particular type of shares can have a meeting as members of those shares. So ordinary shareholders can have a meeting of ordinary shareholders. Preference shareholders can have a meeting of preference shareholders. Founders shareholders can have a, so each class of shares can have a meeting of their own. Another type of meeting, debenture holders. Debenture holders, these are the creditors to the company. They can have a meeting with the management of the company, asking the company, when are you paying? Can you change the mode of payment? Can you increase the deposit, etc., etc. So we have many types of meetings. When you talk about types, we have that. In the meeting, there are elements, and these elements include what? Number one, in order to have a meeting, there must be a notice. Do you know what a notice is? Notice. A notice is that which alerts you, hey, tomorrow, hey, next week, like what I have written on the mail yesterday telling you, hey guys, tomorrow we have a class. So that is a notice. If I don't write the notice and then you miss the class because I did not write the notice, then if we are talking about a company, you can challenge that meeting and say, I did not attend the meeting. Why? I was not given a notice, and yet I am a member. It is one of the membership rights, the right to receive a notice. If you can prove to the court you are a member of the company did not give you a notice to attend a meeting, my friend, even if the meeting discussed and passed resolutions, the court can say all those resolutions are null and void. All those resolutions are useless. Call for another meeting, call this particular member, then pass the resolutions from the beginning. That is how difficult, how serious it is. Now, who is in charge of calling meetings in a company? Can somebody tell me who is in charge of calling meetings? Yes, please. Who calls for meetings in a company? Okay, the board of directors, and they tell who? They tell who in particular to call the meeting?
Company secretary.
Exactly, the company secretary. So the officer in charge of sending the notice to the members is the company secretary. The company secretary is given authority by the Companies Act to call for meetings. Of course, the board will tell the company secretary, call for a meeting, and the company secretary must call for a meeting. In the notice, the company secretary must tell you what is the meeting about, what is the date, and in the same notice, he must include the agenda. Agenda is all the things you're going to discuss. Then there is another very important document he must include in the notice. That document is called a proxy form. The document that the company secretary must include in the notice is known as the proxy form. Let me write this for you in just a bit. So, it is known as a proxy form. Now, a proxy form, number one, what is a proxy? A proxy by itself, a proxy is an agent. A proxy is an agent. That, remember, one of your individual membership rights in a company is the right to receive notices and to attend meetings. And if the company secretary does not give you a notice to attend a meeting, you can challenge that meeting and everything will be null and void. So, the Companies Act recognizes that it is possible you may be unable to attend a meeting for reasons which are beyond your control. E.g., you have corona, you are sick, or you are out of the country, you've gone to Belgium, and whatever the reason. But your rights as a member of the company still exist. Hence, you should know what they are discussing in the meeting. Therefore, the Companies Act gives you the rights to appoint an agent, a person to attend the meeting on your behalf. When you appoint an agent to attend a meeting on your behalf, you must give that agent some written authority. That written authority is put on the proxy form. And that person you have appointed to appear in the company meeting on your behalf is what you call a proxy. We shall discuss proxies. We have special proxy, we have general proxy. That actually is one of the elements of the meeting. So when you talk about the elements of the meeting, at the beginning up there, we will find proxy. The company secretary must include a proxy form so that if you cannot attend, you put the name of a person to attend on your behalf. This person does not have to be a member of the company. You can tell your cousin, your brother, your mom, your neighbor to attend on your behalf. As long as that person is an adult and that person is of sound mind, is not an insane person, no problem. Okay? So we look at the elements of a valid meeting, and then decisions are made in meetings. What do we call a decision in a meeting? The decision in a meeting is what we call a resolution. So we discuss, we want to start a new project in Nyagatare. Some say yes, some say no. And then we do what? The rule in Force versus Habertol, the majority rule, we vote. When we vote, we make a decision. That decision is the resolution. Omubikira Mari, that is another person again who wants the document. Okay, but you people, you are really bringing a problem. You know, remembering and writing all this is going to be a problem. Sawa. Omubikira Mari, I've taken a photo of your name. I'll also send. Okay, sawa. Fine. So the types of resolutions, we are going to look at them. Special resolution, ordinary resolution, resolution requiring special notice. Actually, there are three. Ordinary resolution, special resolution, resolution requiring special notice. Just those three, and we are done. Meetings, very important area. We're going to discuss and understand them. Fine. The next is directors. Directors are very important in the company because directors, where do they come from? The first directors normally appoint themselves. The first directors normally appoint themselves. They appoint themselves from who? They appoint themselves from the promoters. Originally, they were the promoters, the people who came together and they decided they want to form a company. And they wrote the memorandum, they wrote the articles, they bought the assets of the company, etc., etc. These people, the Companies Act says a company must have directors. In the memorandum and articles, they must list down directors. And they have the advantage of appointing themselves. Manzi, I thought Manzi, you were on the list. How comes you're not? Okay, so Manzi, I've taken your name also. So the first directors will appoint themselves from among the promoters. Subsequent directors, future directors will now be appointed by members in a general meeting. At the end of every fiscal year, every financial year of the company shall hold an AGM. AGM is also what we call General Assembly. The General Assembly, after they pass all the matters, resolutions, etc., then the members have an opportunity to appoint one or several directors to carry the company through the next fiscal year. The Companies Act, Rwanda, is very interesting. There are some rules it has directly borrowed from the Companies Act of United Kingdom. E.g., the minimum age of a director. The minimum age of a director under the Companies Act is 16 years, 16. Imagine, that is still a baby. The minimum age of a director is 16 years, but the Companies Act is silent on the maximum age. The previous Companies Act of 2018 was stating that maximum age is 75, but the present one is silent. Likewise, the Kenya Companies Act of Kenya, maximum age, it is silent, but minimum age is 18. Now, there is no specific qualification for a director in a company. There's no qualification. It will be upon the company itself to specify in the articles of association that for our company, the minimum age, yes, including the minimum, for our company, the qualification of a director will be, must be a CPA, must be this, must be that. For our company, the maximum age shall be 75, shall be 80, or they just keep quiet. If they say in the articles, then they must follow what they have said. If they are quiet, then we can pick a Munyonzi as a director. We can pick anybody as a director. Okay? Now, we shall look at their appointment, their disqualification, and their duties. Basically, the duties of directors is to lead the company. They are the top level. They are the top level management. Okay? There are certain principles, certain doctrines which govern directors. Certain doctrines which tell us how directors are to manage their affairs. These doctrines are the indoor management rule, the constructive notice rule, organic theory, the holding out principle. They are the principles which govern directors. I'll just mention an example of the four of them so that we can move fast. Then the others we'll discuss as we start looking at the notes. When we talk about indoor management rule, it is also known as the rule in Tukwand's case. The indoor management rule is telling us something very obvious. It is the people inside the management who know what they actually do. It is the people in the board who know if they follow certain rules, certain principles or not. When they come out to the public and they give the public a document like the Articles of Association, and they tell the public, before we borrow money, we always have a board meeting and we pass a resolution, the public will believe what they have read because the public is not inside the management. Therefore, if the management writes such information, before we borrow money, then we go and borrow. If they have written that, and we, the public, look at that, Becca looks at that document because the board wants to borrow 100 billion. Becca says, show us your articles to confirm that you have the power to borrow this amount and the procedures you follow before you pass that resolution. And then they show Becca that document. Becca will believe because Becca is not inside those meetings. Unfortunately, it then happens that these directors, they have only made rules on the paper, but practically they do not do what they have written. It is like what we are told in church, that they are preaching water, but drinking wine. So if they have written things which are very good, but they do not follow those things, my friend, that is their problem. When Becca gives that money, and later on it is realized that these people did not have the power, Becca has no problem. Becca must be given back their money, and these people will be punished. So indoor management rule is a rule which says that what the company tells the public is bound to believe, because the public is not inside that company. Okay? So we're going to look at these rules. Very simple. So there are cases which help us to understand these principles. Okay? Directors, and another thing about directors, we will realize that we have all kinds of directors. It is the company through its articles of association to tell us what kinds of directors will be in this company. Do they have an executive director? Do they have a managing director? Do they have a finance director? And so on and so forth. Do they have a chairman? All this. Okay. So, then the next chapter is the company secretary. Now, to prove the importance of a company secretary as the foundation of a company, I will start with this. The Companies Act specifically says the minimum age of a director is 16 years. The minimum age of a director is 16 years. 16-year-old person is a baby. He or she may not understand many things. But the Companies Act is very comfortable. Why? Because even if the director is 16 years, and then again, we are not given the qualification of directors. You can decide who you want to put there, including Munyonzi or anybody else. There is an officer who must have specific qualifications, and this officer must be an adult, and this officer is the company secretary. The company secretary is the legal brain of the company. So the directors always look to the company secretary for direction, for legal advice, to confirm that what they are doing is correct, to confirm that what they are doing complies with the Office of the Registrar General. The company secretary is a very important person. Now, the Companies Act 2021 says that all public companies must have a company secretary. All public companies must have a company secretary. But private companies may or may not have a company secretary. So private companies may or may not have a company secretary. Where the private company is a small company. You know what a small company is? The definition of a small company under the Companies Act is a company whose net worth is 5 million. Those ones, they don't even need a company. They should not even bother. They don't need a company secretary. Now, unlike a director, a company secretary requires specific qualifications. This person must be a person who, number one, understands the law, and number two, understands accountancy. Understands the law because he is going to connect the company to the Office of the Registrar General and the Companies Act. Understands the law because the company will be entering contracts, taking loans, debentures, etc., selling shares, etc., and then understands accountancy because there are annual returns, annual reports to be given to the Registrar General. This officer must know what are the contents of these reports. This officer must know if, for example, we are talking about a holding company having its subsidiaries. Must the company give a consolidated statement, or what must it do? So this guy must be qualified enough to understand the law, enough to understand accounting. The duties of this officer are very many. All the documents go through this officer. Arrangement of meetings go through this officer. Ensuring that the debentures and the mortgages are in order go through this officer. Selling of shares, the allotment, etc., go through this officer. The prospectus, all these things go through this guy. Even the dissolution of the company, we are going through this officer. And then cessation of office. How does he end office? Number one, the company secretary is appointed by the board of directors. Company secretary is appointed by the board of directors. His salary and the terms of office are given by the board of directors. The members have no power over the company secretary. Members have power over directors, but not the company secretary. They did not employ him. You can only tell the board of directors that the company secretary is misbehaving. They can only tell the board the company secretary is misbehaving, so the company secretary should do what? Should change. Otherwise, the board should do it. There is an officer who is insisting. Somebody is people mute so that
I don't understand.
Yes. You don't understand?
It's a noise.
Yes. What exactly don't you understand? Yes. Hey, disturbance. Please mute. Nadia, it is you. Nadia, you are the one who's making noise. Okay. So I found it was Nadia. I've muted. Maybe Nadia did not know. The noise is back. Mute, please, so that Nadia, it is coming from your machine. Nadia's machine has a problem. Okay, so this officer is in charge of communication. What we talked about meetings, this officer is in charge of that. Okay. Then something very interesting. The company secretary can enter contracts on behalf of the company. The company secretary can do what the directors are supposed to do, on condition that, one, the directors have given him authority, or the director or directors are not available. He or she can step in. So if a director is not available, company secretary can step in and do what the director is supposed to do. An emergency, for example. And then all the transactions which the company enters, the company secretary is the last person to sign that transaction. When the directors sign the contract or sign the loan, the company secretary does a review, looks at the document, and then signs the document as the last person and puts the company seal. The company seal is simply the company stamp, and the company seal can only be kept by the company secretary. Nobody else can keep it. So we are going to look at all this. We're going to understand it. Not a big deal. It's a small chapter. I think it's about 4 pages, even less. I think three pages or so. Okay. So that is that. Now it's going to 6 o'clock. We're supposed to end, and then we resume yet again at not 6:05. It's going to 5 o'clock. We end and we resume at 5:30. We get back at 5:30 and we see how far we can go after 5:30. We do as much as possible. Our objective is to ensure that we do as much as possible. We make use of this time when we still have time. That is the simple trick. So we stop here at chapter 9. When we get back, we shall move on to chapter 10. That is the auditor. We are going to look at the auditor when we get back to class in half an hour. Meanwhile, I am going to send the document to these few officers. I have taken their emails, and then we see what else. So we end the class, we get back. The link is the same link, 5:30. Sawa? Okay?